Hello everyone, my name is Amber Rouse Holloway and I'm a partner here at our Troy office. In this month's My PIP Monthly, I'm here to discuss some case law updates as usual and some trending topics in PIP litigation. For our case law updates, we'll talk about Farm Bureau v. Hoare, which essentially discusses whether certain policy exclusions are against public policy. Then we'll briefly discuss Banda Taveras v. Elwood Staffing Services, which highlights the strict elements of a negligent hiring claim. And then lastly, for our case law update, we will discuss Spectrum Health v. Farm Bureau Mutual Insurance Company of Michigan, which is interesting as it discusses amounts paid by health insurers like Medicaid or Medicare being used to determine reasonableness within the meaning of the No Fault Act. The Spectrum Health v. Farm Bureau Mutual Insurance Company of Michigan case is especially important while unpublished because whatever amount that the facility received from Medicaid or Medicare can now be presented as evidence to a jury. And lastly, for the trending topics in PIP litigation, I'll give an overview of the assignment of future benefits and how it is in violation of the No Fault Act. First up is Farm Bureau v. Hoare, docket number 347918, and was issued on August 20th, 2020. In this unpublished opinion, the Court of Appeals specifically evaluated whether a Farm Bureau policy exclusion was against public policy or enforceable as written. On the date of the accident, we have a Mr. Omar Khan who agreed to transport several passengers as a favor for his niece, Ms. Barua, who regularly transported passengers as a part of her medical transportation company. She herself was the owner of the company and not Mr. Khan. The two individuals, Mr. Khan and Ms. Barua, did not discuss any payment, and likewise, Mr. Khan did not collect any money from the passengers that he did transport. During the transportation of the passengers, they subsequently got into a motor vehicle accident. Mr. Khan was personally insured through Farm Bureau, and the Farm Bureau policy contained an exclusion relating to vehicles used for business purposes, including being used to carry persons or property for a fee. Following the accident, Mr. Khan makes a claim for no-fault PIP benefits from Farm Bureau. Farm Bureau filed a DEC action against Mr. Khan and others, and Mr. Khan was defaulted. Thereafter, Farm Bureau sought summary disposition pursuant to MCR 2.116C10, advising of the policy exclusion as the reason Mr. Khan was not allowed to collect PIP benefits. Ultimately, the trial court granted Farm Bureau's motion for summary disposition and ordered that the policy exclusion must be enforced as written. The court further examined the issue of whether Mr. Khan transported passengers for a fee and confirmed that he did indeed do so, despite no exchange for payment between him and Ms. Barua or him and the passengers. Here, the Court of Appeals affirmed the trial court's decision by ruling that the policy was enforceable as written. The court expressly stated that the plain language of the exclusion does not require that the insured be the one to receive a fee in order for the exclusion to apply. Because the vehicle itself was being used to transport passengers for a fee, the policy exclusion was enforceable. Ultimately, this is a unique perspective from the Court of Appeals on interpretation of an insurance policy. Although it's unpublished, it can definitely be used as persuasive argument should a similar fact pattern occur in your case or in any case. Next up is Banda Taveras v. Elwood Staffing Services. The big takeaway from Banda Taveras v. Elwood Staffing Services is that unless it can be proven that the employer knew or should have known of the employee's incompetence and the dangers the employee may subject the general public to, a negligent hiring claim will not survive. In Michigan, there's no duty to check an employee's driving record when the position does not require for driving and or checking a valid driver's license. However, dicta from this unpublished case implies that under a different factual set of circumstances, such as employing for a position that does require driving, there may be a duty to check a potential employee's driving record and or status as a legal driver. Unless it can be proven that the employer knew or should have known of the employee's incompetence, a negligent hiring claim will likely not survive. In this case, plaintiff Banda Taveras was involved in a car accident. Defendant Murphy crossed the center line and crashed into plaintiff head-on. Plaintiff eventually brought this action as a negligence action against defendant Murphy, but then amended its complaint to add Murphy's employer, which was Shawnee Specialties, and the owner of the vehicle. Plaintiff then filed a second amended complaint adding defendant Elwood Staffing Services, a temporary staffing agency. It was alleged that defendant Murphy was an employee of Elwood and that Elwood placed defendant Murphy in a temporary position at Shawnee, and therefore they were responsible for his negligence. It was undisputed by either party that defendant Murphy was placed with Shawnee solely as a machine operator. There was no evidence that having a driver's license or driving was a requirement of his employment with Elwood or the employment with Shawnee. Plaintiff went on to allege that Elwood failed to check the status of Murphy's driving license and failed to ask Murphy if they could legally operate a motor vehicle. The trial court denied plaintiff's motion because the proposed amended complaint was insufficient on its face to support a claim for negligent hiring. The Court of Appeals noted that with a negligence action, it must be shown that the defendant owed a legal duty to the plaintiff and that the defendant breached or violated that duty, and that the violation was the proximate cause of the damages suffered. However, there are several elements to negligent hiring that the plaintiff must also meet. Furthermore, there's case law that suggests that there is no duty on the part of an employer to verify a driver's license status of an employee if driving is not a part of that employee's duties. Again, defendant Murphy here was not placed in any position that required him to drive, nor was driving a part of the job responsibilities or duties. Here, the Court of Appeals refused to impose a duty upon employers to only hire in positions that do not directly require driving those with a valid driver's license and or unembellished driving records. And our last case law update is the Spectrum Health v. Farm Bureau Mutual Insurance Company of Michigan unpublished opinion issued September 3rd, 2020. The big takeaway from this case is that the amounts paid by health insurers and others, such as Medicaid and Medicare, may be considered by a fact finder for determining whether the amount a health care provider charged a no-fault insurer was reasonable under the No-Fault Act. Here, the court distinguished prior case law, noting the significant distinction between customary and reasonable. The court held that prior case law precluding consideration of third-party payments in the context of the customary inquiry does not control whether those payments may be considered when determining reasonableness. In the case of Spectrum, the Spectrum Health facility provided treatment to a claimant following a motor vehicle accident. Farm Bureau paid 80% of Spectrum's charges based upon the fact that Spectrum routinely discounted gross charges by 20% for cases not involving insurance. Therefore, Farm Bureau contended charges in excess of 80% were unreasonable. As we all know, pursuant to MCL 3107(1), a hospital charges to a no-fault insurer may not exceed a reasonable charge. Spectrum thereafter filed suit for the remaining balance, and during discovery, Farm Bureau sought information related to the reasonableness of Spectrum's charges. Interestingly enough, Farm Bureau sought the rates Spectrum accepted from third-party payers such as Medicaid and Medicare and Blue Cross Blue Shield of Michigan. Farm Bureau argued that the legislator did not define the term reasonableness in the No-Fault Act. Farm Bureau further asserted that a fact finder should be able to look into the open market and decide valuation. An open market valuation should encompass a provider's cost to charge ratio and the amount generally billed for services. In response, Spectrum argued that the discovery Farm Bureau sought was irrelevant and not admissible. Spectrum contended that Section 3157 focuses on charges and not payments. Therefore, third parties, such as Medicaid or Medicare payments, were not relevant in determining reasonableness. Ultimately, the trial court granted Farm Bureau's motion in part and denied it in part. Notably, the trial court adopted Spectrum's argument and ruled that third-party payments were not relevant in determining reasonable and customary rate for PIP benefits. Farm Bureau thereafter appealed the decision. The issue on appeal concerned the identification of factors that may be considered when determining whether a provider's charge was reasonable under the No-Fault Act. Farm Bureau's appeal brief primarily focused on payments providers accepted for like services from other payers such as Medicaid, Medicare, or Blue Cross Blue Shield. Disagreeing with the trial court's ruling, the court opined that prior case law addressed factors or criteria that may be considered when determining whether a charge is customary. Payments accepted for like services from other payers have no bearing on the customary prong. However, the reasonableness question presented in the case was not addressed. The court held that reasonableness prong does not contain similar restriction as the customary prong, and therefore, the amount others pay for the same good or services is a pertinent factor to be considered when determining reasonableness. Moving on to trending topics in PIP litigation for our September issue, I wanted to discuss assignment of future benefits. The assignment of future benefits is in direct violation of MCL 500-3143. We see this issue a lot in provider cases where a medical facility receives an assignment from a claimant for services rendered, and then that assignment predates the services provided. I also wanted to discuss the bearing of the Covenant Medical Center v. State Farm case on this issue and the effect of no-fault reform on the assignment of future benefits as well. Under MCL 500-3143, an agreement for assignment of rights to benefits payable in the future is void. Again, we see this sort of issue, the assignment of future benefits, in provider suits. So an action for personal protection insurance benefits brought by a plaintiff, a healthcare provider, directly against a defendant seeking payment for medical services provided to a claimant who was allegedly injured in a motor vehicle accident. Plaintiff provider thereafter in its complaint alleges that the cause of action is based on a purported assignment of rights from the claimant. However, the treatment, testing, or alleged medical services provided to the claimant by the plaintiff did not occur until after the claimant executed the assignment. We see this a lot in toxicology screenings where the assignment, for example, was signed on September 21st, but the sample received from the claimant isn't received by the toxicology facility until September 22nd. Thereafter, it is a future assignment because the treatment did not occur until after the assignment was executed by the claimant. In 2017, the Michigan Supreme Court decision in Covenant Medical Center v. State Farm concluded that there is no independent cause of action by a provider, but a claimant may assign his or her rights to collect PIP benefits over to a provider. As we all know, the No-Fault Act was amended on June 2, 2019. Even though MCL 500-3112 was amended to allow direct cause of action by a provider against an insurer, that cause of action is limited to recover overdue benefits payable for the charges for products, services, or accommodations provided to an injured person. Therefore, provider suits are still viable, and a direct cause of action for providers has been codified. A healthcare provider may still make a claim and assert a direct cause of action against an insurer to recover overdue benefits for the charges or products, services, or accommodations provided to an injured person. Basically, I'm saying all of that to say that future assignments are still not allowed even though a provider is able to seek a direct cause of action against an insurer. Two cases that demonstrate the validity of the assignment of future benefits are Michigan Ambulatory Surgical Center v. State Farm Mutual Auto Insurance Company and the Aetna Casualty v. Starkley case. In Michigan Ambulatory, the court distinguished when the assignment is for accrued benefits and future benefits. According to Michigan Ambulatory, an assignment is valid if it clearly reflects the intent of the assigner to presently transfer benefits or rights to the assignee. Going hand in hand with the Michigan Ambulatory case, in the case of Aetna Casualty v. Starkley, the assignment at issue there assigned any benefits from Aetna which would become due and payable as the result of medical treatment and care. The key word here is would. It would only become due and payable after the care and not before. Obviously, a future assignment of benefits does the exact opposite. And that concludes our September 2020 episode of My PIP Monthly. Again, my name is Amber Rouse Holloway, and thank you for joining us today. If you have any questions or no concerns, please feel free to contact us. Thank you.